Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukar. Normally, we feel that it is the duty of the state to oppose any bail, any appeal filed by the accused because the state is supporting the accused, the victim person. But Supreme Court became very serious on an IPS officer by name Ashok Misra IPS, SP Senior Superintendent of Police Samastipur, Bihar, for filing an affidavit. Actually, it's a counter affidavit. For filing a counter affidavit supporting the accused in the appeal. Supreme Court felt a very awkward situation. A man of IPS card, whose signature has got so much of value, but this man files affidavit supporting the accused. Honorable Justice Asanuddin Amarullah and SVN Bhatti of the Honorable Supreme Court. In the case of Madhuri Devi versus Arjun das alias Kaniya and others, SLP number 2126 by 2025 on 1st August 2025, directed the personal appearance of the IPS officer along with his personal affidavit, as Honorable Supreme Court took a strong exception to the casual conduct of the senior IPS officer. Actually, whether they like or not, they have to contradict the version of the accused person, but they supported the version of the accused, or they supported the accused and countered or contrasted the case of the state's prosecution. Now, the result is he was given a show cause notice and was directed to appear before the court on 19/8/2025. Right. So, here, better to understand the background story. Arjun das alias Kaniya's wife, she filed an appeal against the sentencing of her husband, or she filed appeal for the reduction of the sentence period of her husband. Normally, the High Court asked the remarks from the state, particularly from the State Superintendent of Police, and when the matter came to they were not allowed. When the matter came to the Supreme Court was stunned to note that the affidavit, particularly para numbers 13, 14 and 15, they are in support of the accused person. Then immediately they called for the remarks of the state, that is prosecution agency, the public prosecutor. Then the Superintendent of Police, who filed the affidavit, he said, who countered the appeal, he has filed the affidavit stating that due to inadvertence, due to oversight, the mistakes have crept in. He supported the prosecution in para numbers 13, 14, 15. Right? సో చూసుకోలేదు, ఇన్అడ్వర్టెన్స్ బై మిస్టేక్ జరుగుతుంది. ఎందుకంటే కింద వాళ్ళు పెట్టిన దాన్ని సంతకం పెడుతుంది కదా, ఐపీఎస్ ఆఫీసర్ హీ డజంట్ డ్రాఫ్ట్ ఇట్. బట్ ప్లీజ్ రిమెంబర్, the Supreme Court was not at all satisfied with his explanation. Suppose if it is at one page or some other paras, it is evident that is due to what? Inadvertence. But how can a long affidavit in which 3 full paras are supporting the accused, how can it happen? Only in 2 ways. Number 1, the officer either failed to read what he was submitting. That is called gross negligence. He might not have at all gone through the contents of the affidavit. That is gross neglect of duty. Or that means either he failed to read or intentionally supported the accused. This is more dangerous. Intentionally supported the accused. That is deliberate misconduct. Is it not? So the apology filed by the senior superintendent of police was refused because in the view of the Supreme Court, the mistake is not accidental. Because three substantial paras, they support the accused person. So from his conduct, it is evident that either he has done gross neglect of duty or deliberate misconduct. So it is high time that the court takes cognizance or judicial note of such conduct of senior officers. Actually, IPS cadre, these senior officers are duty bound to uphold the rule of law, but they are acting in a manner which is prejudicial to the interest of the state. If this is the state, if this is the situation, how can they maintain the law and order under their jurisdiction? It shows the casual attitude of the officers. And JP, Supreme Court has gone very seriously. The matter is posted to 19/8/2025 for the personal appearance and personal affidavit of the so-called Ashok Misra. So how it is happening? Practically we also have to think. So this is the mistake of cut, copy, paste. And depending on the so-called junior officers. That's why whenever you are filing an affidavit before the court, you must be fully aware of the facts mentioned in the affidavit. You must have full knowledge. Otherwise, if the court asks, you should reply. If you are not able to reply, then immediately the court will retort saying that who drafted this. Number one. Number two, you must be doubly sure, at least even though you don't find time. I agree, because IPS officers, they will be overburdened with so much of duties. They have to attend the minister, they have to attend the video calls, they have to attend the DGP on some occasion like that. They may not be able to find time. Even in such a time, there are special branch inspectors or somebody. So that fellow should have gone through the contents. Here the problem is, so nakunna problem ఇది. 1 or 2 times కరెక్ట్ చేస్తాను, థర్డ్ టైం సరిగ్గా కుట్రావా అని సంతకం పెట్టేస్తాను. థర్డ్ టైం ఏదైనా మిస్టేక్ అయ్యింది. అండ్ ఐ వాజ్ అడిషనల్ ఎస్పీ బిలీవ్ ఒంగోలు, మార్కాపూర్ డిఎస్పీ కుర్రాడు ఆయన. He sent a GCR. Luckily, I got through. Additional SP డ్యూటీ మెయిన్ పనే ఉండదు పెద్దగా, అడ్మినిస్ట్రేటివ్ డ్యూటీ కాబట్టి చదివాను. చదివితే 304A రోడ్ యాక్సిడెంట్ కేసు, 302 మర్డర్ కేసులో సీనియర్ అఫెన్స్ రాశాను. బికాజ్ ఇట్ అందుకే నేను చెప్పానే, కట్ కాపీ పేస్ట్ వచ్చే ప్రాబ్లం. యూ మస్ట్ బి వెరీ వెరీ కేర్ఫుల్. దిస్ ఈజ్ అన్ ఐ ఓపెనర్. ఎందుకంటే బీయింగ్ అన్ IPS ఆఫీసర్ గోయింగ్ టు ద కోర్ట్ అండ్ గెట్టింగ్ scathing remarks by the court, is it necessary? No. So please, whether you are a sub-inspector, whether you are a DSP, whether you are an SP, please treat the court in a cautious manner. Therefore, before signing, check up whether it is correct or not. Otherwise, these problems will come. I am stopping here. Thank you.